I'd like to call this meeting to order. We don't have too many people in the audience, but tonight we will be holding a public hearing of the Eugene Planning Commission to consider land use code amendments related to annual maintenance of the code. Before we begin taking testimony of anyone who would like to speak, I'd like our planning commissioners to introduce themselves and then provide some time for staff to introduce the topic. My name is John Jaworski. I am the chair of the Eugene Planning Commission. The other planning commissioners are as follows.
Jeff Mills.
Stephen Baker.
Brina Cavallo.
Bill Randall.
John Borofsky.
Tonight we also have the following city staff present.
Robin Hostick, Planning Director.
Alyssa Hanson.
Ann Davies, Assistant City Attorney.
We'll begin with a brief presentation from staff and then open the public hearing. If anyone in the audience would like to speak, please fill out a request to speak form. There are green cards in the back, and bring it forward to staff. Just a reminder that the Planning Commission will not make a final decision on these proposed amendments. We will, however, be making a recommendation to the City Council, who will hold their own public hearing before making a final decision. We will begin with a brief presentation from staff. I'll recognize Alyssa Hanson with the Planning Division to make the staff presentation for the proposed code maintenance amendments.
Okay. Thank you. As you mentioned, tonight's public hearing is on amendments related to annual maintenance of the land use code, and if time permits, you also have the opportunity to take action tonight, which would be a recommendation. So as you may recall, last year, in recognition of the need to regularly improve and maintain our land use code, the code maintenance program was initiated by City Council, and the inaugural batch was approved last year. So this is our second set of the annual maintenance code amendments, and this set includes a modest number of discrete amendments that address either corrective or legal issues. And essentially, if we don't address these, they really pose a challenge in our day-to-day administration of the land use code. So the majority of these are corrective amendments, and what those do is they're intended to fix errors or conflicts, and they do this in a number of ways. I think the vast majority, or many of these, are correcting code citation references. There's also some that remove obsolete language, and there's others that clarify the intent by adding language that was inadvertently omitted. There's also a handful of legal amendments. These respond to changes in state law, such as revisions to the Oregon Revised Statutes, to remove conflicts between provisions in the code and newer state regulations. These come from a variety of sources. They do mainly come from planning, building, and legal staff. We kind of discover these during our daily implementation of the land use code. Often we're working with property owners at the front counter or during our review of building permits or land use applications. I've even had some staff text me immediately following a project consultation with a picture of the code section. So I think it's kind of gotten instilled in our staff to really pay attention to these, and we will get them fixed. To ensure that code maintenance amendments remain manageable within our existing resources and work program, these amendments do not address policy issues or topics that are associated with other Planning Division work program items. Notice of the public hearing was sent to all neighborhood organizations in Eugene, as well as the Oregon Department of Land Conservation. We also sent notice to community groups and individuals who have requested notice. Notice was also posted in the Register Guard, and we do have a website that where we post upcoming code amendment information, and we've received no testimony to date. The applicable approval criteria are found in section 9.8065 of the Eugene Code, and these are provided for you in the agenda item summary for tonight's hearing. Following the public hearing, your role will be to deliberate on the proposed code amendments and provide a recommendation to council. In the event that you're not able to finish deliberations or recommendations tonight, we will be setting a deliberations date, hopefully for mid-August. We're still ironing out the schedule for August because we have a couple other items we need to move around. Council, it's likely that their public hearing, which would follow your recommendation, would occur in October based on their current schedule, and then action would be following their public hearing. And that's all I have.
Thank you. At this point in time, I'd like to open the public hearing. If anyone in the audience would like to speak and if they haven't filled out a green card, please do so. I see an individual. Would you like to speak, John? No? All right, we don't have anyone who would like to speak. So with that, we can move right on and ask planning commissioners, do we want to have this record closed or do we want to have the record open for any period of time? I hear no one making any motion to any effect, so I will then declare.
Well, I have a question on that. Do we have to decide that right now?
If you want, we could go through some questions,
Yeah,
and that
let's
maybe
do
that will inform.
I have a question that if it's answered one way, I want the record left open. If it's answered
Okay.
a different way, I'll close it.
Which way is what? No, I'm just kidding.
Chances are it's not going to be a problem.
I'll recognize Commissioner Borowski.
Okay. So my question has to do with the notice given. And the reason I'm saying that is because, and this kind of goes to past this and kind of to our public outreach. This meeting wasn't published in the city's public meeting calendar for this week. It wasn't published in the Register Guards public meeting thing. I ended up I dug, and I'm pretty good at going through the city's website. It took me about 20 minutes to find this meeting and the only way I did that was through the archive or through the agenda. That was the only place that I could find that this meeting was posted. I did a search of the Eugene Register Guards classifieds for public hearing. It didn't go. I think it probably went in on the 10th. It would only go back to about June 15th is where I could go to. So if you can give me the date that actually hit the Register Guard, that would be something. Because I can't have a public hearing we can't have public hearings if the public doesn't know about them.
I don't have a copy of that with me,
Right.
but I did sign the bill that had the picture of it, and I did see it in the Register Guard.
Okay.
It's at my desk.
The other thing is, it says that it was sent to the neighborhood organizations. I'm a board member of a neighborhood organization. I never saw something come in front of me. Now that could be from my organization's thing, but it's just worrisome to me when you have a public hearing and there's nobody knows about it. Okay, so when I went to the cities, and I've got it printed out here, tonight's agenda, there's the Jefferson West Side, Civilian Review Board, and Southeast Neighbors. That's all that's listed on the public meeting calendar for the city of Eugene. Planning Commission calendar, same thing. Planning Commission says, Harris Hall. So that concerns me as far as these findings. I'll take your word that it hit the Register Guard because that's the legal notice. But I'm concerned about public hearings that aren't public. And so if you give me a Scout's honor that it hit the paper at the legal thing, then I'll be fine with having
Okay.
the record closed. But
It absolutely did meet the legal requirements, and it did go to to two people in Fairmont. It was mailed, so it was mailed to all the leaders of the neighborhood associations and a number of other folks, and we did send the legal ad, and
okay.
I know we paid for it.
Yeah, and I'm sure it was. It was just when it didn't hit the register or the city's meeting calendar. I could see it not hitting the little one in the Register Guard because that one is you got to call them and do it. But when it's not on the city's
Okay.
meeting,
No, we'll follow up on that. So
that gets back to our issues of trust.
right. Okay.
If I could just make a comment, Commissioner Borowski, I really appreciate you bringing that up because We feel it's very, very important to have an informed public. That is a huge, huge part of what we do. So anything we can do within reason, of course, that makes it more accessible, more available to the public, we definitely want to look into that. So thank you for bringing that up.
So my question is, was the question satisfactory to keep the record open, or was it satisfactory?
No, I can have it closed. The reason I would have had to keep it open was if that notice hadn't published, then the goal one finding wouldn't be up to my snuff.
Is there any other commissioner that has any concern whether or not to close the public record? Hearing none, I officially close the public hearing and record. At this point in time, are there any question that commissioners wish to ask of staff? Commissioner Mills.
Yeah, and my questions are not with, nothing more than with clarity, to make
Okay.
sure I understand what the intent is. And I'm looking at item 13, application for completeness review. And I've read this, and I think I understand that it's possible to do this, but I'm not quite sure. It sounds like this has to do with final plat applications for petitions or subdivisions being moved to type 1 and the requirements associated with that. And I'll go ahead and read this. As a result of this change in process and recognition that requirement for completeness review is not practical because these applications are not technically complete until the official final plat is ready to be signed and recorded, which is at the very end of the review process and can often take more than 180 days, final plat applications need to be exempt from this requirement. And I just, my question is this going to work? I understand what we're doing here. We're saying we can't, that the time, review time for a final plat is too, this is the way I'm interpreting this. We can't turn it around in that time, therefore we're going to exempt it.
And it's actually it's two parts. So one, state law does not require that, state law requires that a number of our application types go through this formal completeness review process. And so this is a code section that's kind of imported from state law. It's not intended to apply to type 1 applications, which are partitions and subdivisions. Not to say that we don't review them for completeness, we absolutely do, but they're not, practically speaking, it doesn't make sense for them to be subject to the remainder of this section, which is making them say, okay, I'll submit the missing information. The way the process works, they always do submit the final plat, otherwise they're not going to get approved. And it's correct, it often does take longer, particularly in a larger subdivision. There's a lot of back and forth between their surveyor, our surveyors, Lane County surveyors, and that can often take more than 180 days, and this would make that application void as it stands right now.
Okay, so, Alyssa, I want to make sure I'm not misrepresenting what
Okay.
you're saying. I want to make sure I understand. So
Yeah,
really,
okay.
this has to do with the give and take of all of the materials going through the process, including the plat, and we're exempting the plat only from this?
The final plat application, it's the whole
Final plat
application.
application.
Yeah, so it's an application type. So after you've got your tentative subdivision or partition approval, it's a second step that you have to apply for. And so those wouldn't technically be complete until they're ready to hand in. We used to call them Mylars back in the day.
Right, yeah.
Now they use paper. So when they're ready with their final paper plat, the official plat, then it's actually complete. It's a complete application.
But they've done the rest of the process with preliminary plats. Is that what we're saying here?
Yeah.
So you've got a preliminary set that you're going to the counter with.
Right. And that's what we send over to the county and to our surveyors to look at.
Oh, okay. I know enough about this in terms of the permitting process, having done it a few times on projects, but not nearly as much as some of the other folks here, to just be dangerous. I understand that the good intentions and the good intent here. I just want to make sure we didn't build in some kind of catch-22 in doing this, that we're not going to get something approved because we only had the preliminary, because the final is exempted.
No, so that, I mean, we still have to, they still have to meet all the, all the Ts have to be crossed, all the Is have to be dotted. There's still a number of, actually, state laws that a final plat has to meet,
Okay.
and this wouldn't exempt them from that.
I just want to throw in just something to help understand the context. This code provision, like Alyssa said, comes from a state statute, and it's the state statute that's the 120-day rule. And so this completeness stuff is all a way of determining when that clock starts. So this code provision, we actually, when we adopted this code provision, we included a lot more things than what state law required us to put with the 120-day deadline. So this just takes some of those back out. The state law doesn't require those. I mean, all the reasons that Alyssa explained, but I just wanted to explain to you that this code provision comes from the 120-day provisions of state law, which do not apply to final partitions and subdivisions.
Can I follow up?
Sure.
So just to ice this a little bit, so what we've done here isn't going to increase the complexity and duration of the average application?
No, absolutely not.
Okay, I guess that's kind of the bottom
Okay.
line here, we're trying to make sure we don't make ourselves, any more
No,
complex.
frankly, it'll make it less complex, because right now we have to go through some interesting gymnastics to make this work under
Kinda
the
got that.
current procedures.
I think I've got it. Thank you
Okay.
for your
Okay, but you were
efforts in answering my
concerned,
sideways questions here.
you wanted to, just to clarify, so you want to make sure they weren't exempt from any standards that they had to apply, and that this wasn't going to add time. Is that what I'm understanding?
Not so much, I wasn't so worried about exemptions. I was worried
Okay.
about some kind of inconsistency in application, which it sounds like you have now,
Right.
and that you're trying to get
It's
away from.
really awkward at this point. Yeah, it's
Thanks, Alyssa.
difficult. So-
Okay, I have, I believe, Baker. Did you have your hand up?
Well,
Commissioner Baker?
yeah. I'm just wondering if there shouldn't be, it's still a little confusing to me, it seems, because of on 181st day after being submitted. So you say other than just for application completeness review to be completed, it would be useful to say that you need the partition or subdivision final plat. So it's clear that we're not exempting an applicant from not having to supply that. Because if the way it's required is you have to have a completeness review and it has to be approved. And
Okay, I'm not sure I'm following. They'll still have to submit the actual plat. This is just exempting those application types, so the code calls them, the actual application type is subdivision final plat. That's the actual application type, but the plat is also part of what gets submitted with that application type, so I'm not sure.
Okay, so there's no requirement that an application completeness review be done on these applications?
What does state law require for type 1s?
Those are not included at all in this
Right.
provisions about completeness.
Okay. So, but we would continue to review them as we always do, and typically those go directly, for the most part, over to our surveying staff, because that's what they're looking at to make sure that,
So
the monuments are it's not going to change our
So
internal process.
So there isn't any requirement for application completeness review on these projects at all?
Not on the final plats.
No,
Is that what you're talking about?
But on
Right.
these projects at all that would be affected by,
Right, which are the partition and subdivision final
what
applications.
about the other parts of that, other than the final plat?
That, the whole application, I guess I'm not sure I get your question.
Where all this exempts out is the final plat. So you've got the
The
tentative.
final plat application, like the whole application, not just that
It says
component.
partition, so it says, other than a partition, so it's saying that, really what it's saying is its partitions to subdivision final plats are exempt from application review.
No.
No, from the completeness review.
Well, that's what I mean, application completeness.
So the final plat applications are exempt from this particular, this section in the code. That doesn't change what we're going to continue to do internally, which is we have to review them. That would be the
Right.
only way
So-
we could determine if they were ready to go.
You said that they're not required to go through an application completeness.
No, if I said that, I misspoke.
Okay.
I meant that they don't have that timeframe requirement that everything else does. The 120-day thing.
The statute, there's not something specific in the statutes.
Is another way to say this that you go through the completeness review with a preliminary plat and not the final plat as an application? Is that when the completeness review would occur? I think that's what
Yes.
Yeah,
Commissioner Baker's getting at.
Because I was thinking, what you'd say is you'd add 4 and you'd say upon receipt of a preliminary partition or subdivision plat. Because you'd need that for your completeness, or do you
I'm not-
or don't you need it for a completeness review?
I'm not sure this isn't one I want to do on the fly,
No,
frankly.
I know, but I'm just, that was my concern.
Okay.
The way it was
And my
worded.
assumption is that it would be used, that the preliminaries would be used if required in the completeness review.
Commissioner Randall.
I'm going to go ahead and jump in here to the queue because we've actually done these sorts of things before. The completeness review is really just when you submit something in general that determines whether it's complete for the city to start that state mandated time clock. And the idea, I think, that Alyssa is saying is that for a partition or a subdivision final plat, it's already gone through preliminary, final plat, that if you start that 120-day time clock, then it can sometimes take longer than that time frame to get everything worked out with the county surveyor, the city surveyor, and the applicant surveyor. And so by exempting this, you're actually keeping applications from potentially being kicked out, saying you didn't make the timeline, sorry, start over. And it really will make it simpler and better for the applicant to get that final subdivision plat done and not be subject to that completeness review to get that time clock started. And am I saying that right?
I think that's right. And another way,
It still has to go through the whole process. It still has to meet all the criteria, all
Right.
of those things. None of that goes away. This is just completeness
When an
review.
application is complete, that's when we can either issue the decision for a type 1, which
Right.
is what happens with these types, or go through what the process is for either it's a hearing or, a planning director decision.
So by not having that in there, once you get your final plat, it is complete.
It is
because
complete, and
otherwise
then-
it wouldn't be the final
right,
plat.
and then
you
we-
can just issue it,
right.
get it done, and
Because essentially, when
Yes.
we have the final plat and it's been signed by the city surveyor, that's when we actually issue the decision. And it's it's
Mm-hmm. and
complete.
it really isn't complete until that point.
And, right, so in this case, it's complete and the decision gets issued all in one fell swoop.
I believe I had Commissioner Borowski that wasn't your hand.
Okay.
Do I have any other hands up at this time? I had a question. Could you clarify something we spoke about, number 5? And if
Yes.
there's a change in that, they might like to know.
Yes, so absolutely. This is the one about the Eugene Parks and Recreation Plan, which was repealed back in 2006, but we didn't remove references in the code. And so what we had proposed here is just remove those references, but John actually had an idea to replace it with a generic term rather than continually update it with, because we seem to rename our parks plans different things when we do them. And so instead of eliminating it altogether, is replace those words with Eugene's applicable parks plan. So it would read, implement the Metro Plan, Eugene's, actually, I think the first one would stay because it says other applicable plans. And then under 9.2620, the PRO zone terms, we would say the determination of park classification shall be based on Eugene's applicable parks plan or by the city manager.
I had made that comment because when there isn't a parks plan, the city manager makes that decision. And if they cross that out, it would mean to me that the city manager is always making the decision until they have another review to come through a public hearing and put something back in. So I said this way, he still can do that when there isn't one adopted by the city council, whatever. And so that was much easier, so they wouldn't have to come back again.
And I did confirm with Carolyn Burke that yes, indeed, the upcoming parks plan will touch on parks classification, so that will continue to be accurate. So that is, we recommend that suggestion. I think it's a great idea to add in.
Do you need a motion for that? Do we need to do that as a motion?
Maybe at the end. I mean-
Well, I was just, since we were in the question phrase, I was just saying something that has been changed in here. Is there any other commissioners with questions? Commissioner Baker?
Well, the only thing about the wording you have there is it says it's either the plan or the city manager. And I think what you really want is the plan, or, if the plan is not in place, then, or if classification is in place, then the city manager would make the determination. So it's just, I'm fine with what you want to suggest, but just in terms of the wording, it's probably not exactly what you really wanted to change it to.
So you're saying, or if it's lacking, then made by the city manager?
Yeah. So, I mean, again, if that's what you meant, if you
That's
meant
what
that
I
either
meant.
one of them
Right.
choose, then.
I don't think we're going to bother John very much with park classification, so hopefully we can cover them all in the plan.
Any other commissioners with questions? Okay, since the,
On that one, or just on any questions?
okay, this is a fine line for me, and because if we're asking questions of the staff, we could actually do that if we wanted to go into deliberations, which is what I was going to move to. Since the record has been closed and the public hearing is over, would the planning commission like to deliberate tonight?
Yes.
Yes. So with that, we'll open up with more detailed questions. And Commissioner Baker, you said,
No, I'll hold off for a minute.
hold off.
Okay, well, because I've already spoken, and maybe some other people.
Well, are there any commissioners that have anything during deliberations? Seeing none, I fall back to Commissioner Baker.
Okay. Just, I had a question on the wording of the downtown zone. Can you find
Here,
that?
tell me what, it's either 9 or 10,
Yeah.
the downtown west side.
And just, I know the intent there, but the wording still seems a little confusing.
So which one, are you talking about 9 or 10?
Well, my question on 9 was, I'm assuming that the special area zone is all R4 or commercial?
Well, it's special area, so are you talking about the designation, the underlying designation? I did look at this, it's a mix. It's honestly a mix, but the code says to use the development standards for the R4 zone.
Okay, because the only reason, again, was a sort of a wording and understand, just so if we're going to change it, let's try to get it right. Because this says comply with for the R4 zone. That would, and that would apply to all of the, in other words, that would apply to bed and breakfast throughout the zone. And so if they're,
Correct, and that's the intent.
okay, so that would, yeah, the point is, but if there's some R3 zones, then.
But they're not, I mean, they're all zones special, they're all zones, it's all a special area zone, and it says, hey, any kind of residential development needs to comply with R4, even though it's a special area, and so.
I just wanted to clarify that there weren't
Right.
any other ones that were dragging in.
No, and so actually the problem is right now is it just points you over to that bed and breakfast standard and you look and it's, you can find the standards for AG and R1 and R2 and R3 and R4, but you don't know what to do if you're in the downtown west side.
You dealt with that?
Not specifically, but I've dealt with areas of the code where it refers you to something that.
And then
there
it's
isn't.
just-
It's like,
Right,
there's no.
right. And there may be only one,
Don't know what to do.
we think the Oval Door may be the only bed and breakfast, but they comply with the R4, so.
And I just, clarification on number 10 too,
Okay,
again, because, so what you're saying here is that it requires 20% of the development site in living plant materials, and the current code language sort of excluded parking areas?
so yeah, so the table, you'll see in the table where it says minimum landscape area, what's crossed out is that it does exclude parking areas, but you'll see that little sub 8 right after minimum landscape area, and that brings you to this special standard at the top of the next page. And that special standard then says, oh, hey, you can count your landscaping in parking areas towards your minimum landscape requirements. So it's a conflict.
Okay, so all we're doing is we're making it clear that it does include parking areas.
Correct. We're going with the more specific.
It does, but
Right.
the table doesn't. Okay.
Right.
That's clearer now.
Yeah, this is actually really helpful because I'll want to make these clearer for council as well.
Yeah.
Are there any other comments and questions or for deliberation? Okay. You feel that we can provide a recommendation to the city council tonight? All right. Does legal feel that we would need to just include in our recommendation or make a motion relative to number 5? Because that was the only really word changing that we had suggested.
Yeah, I mean, safer just to make a motion, might as well, to
Okay.
put that language out there clearly.
So I would look for a motion relative to number 5, Parks, Recreation, and Open Space, on the issue we were talking about concerning, based on the an applicable Eugene Parks and Recreation Plan, and if not in place, then made by the city manager, something to that effect.
For item 9.2620.
9.2620, correct,
Right.
pro-zone terms.
Could we ask staff to read the original proposed change, and then we could,
Okay?
I have a proposed wording when we get there.
oh, that's, go ahead.
Is it? Okay.
I don't
I'll
know.
recognize
Yeah.
Commissioner Randall.
Okay. I propose that we modify 9.262 to read, "The determination of park classification shall be based on Eugene's applicable parks plan or in the absence of a plan by the city manager." Does that say what you were concerned about?
Do I have a second? Seconded by Commissioner Mills. Is there any discussion?
Can I just ask a quick
Commissioner?
clarifying question? So in the original one I have, it says shall be made by the city manager. Is there a particular reason why we want to add in language that would say in the absence of a plan by the city manager? That feels a little prescriptive. I'm just curious as to what the rationale is behind that, as opposed to using or something like that.
Well, if there is an applicable plan, I don't think the city manager would make a decision that would conflict with it. But the point being is that this allows staff and/or legal to make the plan based on the adopted PROS plan without having to even involve the city manager. But if there is no plan, then it's stating that it then goes to the city manager for some sort of ruling.
Yeah, that's totally understandable. I was just curious how we transitioned from having the language of shall be made by the city manager into having language that says in lieu of a parks plan, it goes to the city manager. There's a big difference between those two things. So I just kind of wanted to know what the rationale is. And I realize this is a very oddly specific, hyper-targeted thing to bring that up, but
You might want to mention that the
We're only
current
30
one,
minutes in, so.
the current one is not.
Yeah,
Melissa, you might.
Well,
want
I
to
mean,
mention-
right now, this particular parks plan that's referenced in here isn't even in existence. It's been repealed. We do have another parks plan that does talk about classifications, but at this point, you'd have to go to the city manager.
Oh, totally. I mean, if
Yeah.
staff and legal is okay with the proposed language, that's totally fine. I just thought it was a little bit weirdly
Yeah.
specific. So,
I'm fine either way, so.
okay.
Commissioner Borowski.
I withdraw my comment.
And I'm leaning towards or by the city manager, because there may be, in the future, we may have a parks plan, an active parks plan, but we may have a new park that needs to be classified. And do we want to have to amend the parks plan to get it classified? Because the way that Bill wrote it, it says if there is no parks plan, then the city manager can do it. So that, I would feel a little bit more comfortable with or, so that
Yeah.
going forward, if if we missed a park in that park plan, a classification, or the classification needs to be changed from a neighborhood park to a something like that, we don't have to go and amend the parks plan to change the classification.
That's
If I may
essentially what I
ask
was-
clarification, it is my understanding that when and if we have this parks plan, within it, they have what the park classifications are with long definitions and their criteria.
What if it changes or a new park gets added? Then
A new park can get added, and then it's up to staff to look at that classification that's in the adopted plan and say, is this a neighborhood park or is this kind of park? Is that what you're saying?
again, the word "or" gives a little bit more flexibility to me, and that way it seems that we may come back and say, oh, next code amendment, we need to amend the parks plan because the Charnel Mulligan moved from a neighborhood pocket park to a I don't know.
Are you proposing a friendly amendment to the motion?
I'm actually ready to reword it.
That's what I was asking because I saw you.
I think I understand what he's asking.
Okay.
Both
What Bree was talking
Commissioner,
about.
yeah, I mean, Commissioner Brodsky and I are saying the same thing. The having "or" in there makes a difference, and let's make people's lives easier in the future, just in case things happen.
Okay, so we have a motion to, a friendly amendment to it.
Let me just restate the motion, and then we can have discussion.
I'm going to withdraw my second,
Oh, okay.
because I'm not comfortable with the wording, with the word "or." I think it provides too much fiat to the manager and allows him to overrule the plan, or implies that it can be either or. In the way it's worded now, it gives preference to utilization of the plan document, and if the plan is not available, then it goes to the city manager. I think it should go to the plan first. And the city manager shouldn't have the ability, if it just says "or," he can say, forget the plan, I want to do this. I don't like that.
Although frankly, that is how it is worded
So
now, and it
that's-
hasn't been a
No,
problem.
I understand,
And I'm
but
going
if
to
we're
bring up
rewording it.
a different point with regard to that, which is, it hasn't been like that. I'm not taking one position or the other, but the code maintenance provisions, when we do code maintenance, we're just trying to fix things. And what we were trying to fix here is the fact that there is no Eugene Parks and Rec plan. And what it said before was shall be based on the Eugene Parks and Rec plan or
Gotcha.
right, or by the city manager. So I'm just.
Where the way it's worded
Neither
now,
here nor-
it is in effect a policy change.
Yeah,
Gotcha.
could be viewed that way.
Commissioner Randall.
Well, since the second has been withdrawn, let me,
I'll keep this,
You keep the
given
second?
that discussion, I'll keep the
Okay.
second in, Bill.
so,
So we have a motion to amend that's been seconded. Would we like to take a vote on the
You
amendment?
haven't made a motion, have you?
Yes. I thought you did. I'm sorry.
I mean, if it's something that could be interpreted as a policy change, then, maybe what we can do in our findings, because council is going to be the ultimate decision maker on this, maybe what we can do is simply state that, there was discussion, this is how we were thinking, state both of these potential language options, and then staff can provide further interpretation, because, we don't want to make some sort of, we maybe want to put a little bit more thought into this than maybe what we have the ability to do right now.
can I ask a question at this point? If I want to reword this so that it gets to what I think is more of a code maintenance thing and not a policy thing, how do we, since we have a motion and a second, we need to go through
Withdraw.
that, or can I withdraw the motion and offer a new one?
Yeah, let's do that.
Okay.
Does
so
that work with everyone?
Are you withdrawing?
Withdrawing the
I
motion
think
and
I'll
restating
withdraw
it.
the motion and suggest a new one. And I
Okay,
don't know
and
how
then I
that
have-
affects Commissioner Mills' second.
That's all right. Go ahead and read somebody else might second it.
Okay. So, new wording. The determination of park classification shall be based on Eugene's applicable parks plan or by the city manager.
Second.
There- Seconded by Borowski. Is there any discussion on this, Commissioner Baker?
I think the likelihood of us coming back to deal with this as a policy issue is pretty small. So if we feel that the change we're about to make is reasonable and not a significant policy change, I think it's perfectly reasonable to fix the code now rather than sort of put it off. We're not going to deal with, I mean, when we deal with minor code amendments, they're not so minor. We're not going to, we're never going to come back and revisit this. So if we can fix it with a few words, then I'd say we just fix it with a few words. And although in the context of the issue, we might theoretically be changing the meaning from what was here, but the way it's been interpreted all these years is if a parks plan doesn't have a classification, then they went to the city manager, and we could just change the wording so it says that.
Matches our practice.
Yeah.
Which is what "or" does, correct?
No,
Yeah.
or doesn't. Or says either one can make a decision.
That's right.
Or is the way it's written. If we take
Yeah,
"or"
it's-
out, in my opinion, that's the policy
Right.
change.
But we take it, I don't understand how you determine a policy change, because for me, we're taking other words out of other things, which to me are policy changes.
Well, in this
too.
case, though, I brought that issue up just because in this case, the change that we're making is taking out the Eugene Parks and Rec plan because it doesn't exist.
right.
That doesn't exist anymore. So when Alyssa first raised this issue, it was, well, that's wrong. We need to just take it out. And then there was some discussion around, well, should we put in the applicable parks plan? So it's incremental policy.
Well,
is
I'll ask my question again, because I've been dealing a lot with parks personally on some other issues, and I was told that the classification is based in the parks plan, if it was produced, by what the definitions of those parks are, either a neighborhood park or a community park. It's not a determination by someone looking at it and say, well, there's no parks plan, this is a community park. It's because it says it has to be so many acres, it has to be so many this, it has to be that. So I think that, you know, when you're saying one or, I could not support just or. I think if there is an adopted parks plan, personally, I feel that that's what you use, because it identifies what those classifications are. Who else did I have?
Can I
Commissioner Nicolello.
make a recommendation, just so it matches 9.2600? Just, can we just remove reference of the city manager, because in 9.2600, you say implement the Metro Plan and other applicable plans. So can you just say the determination of park classification shall be based on the Metro Plan and other applicable plans? I mean, do we have to have the reference of the city manager? Because that seems to be the divisive part.
In my opinion, that adds even more policy choice.
Yeah, and the Metro Plan doesn't touch
And
park
I would-
classifications at all.
Okay, then I would really urge my former recommendation of saying, maybe what we do with our findings, and I can make a motion to this effect, is when we have our findings, let's request that staff includes some information in there about the conversation that we had about this language, and that we did discuss, or versus the other language, and just state that warrants a larger conversation, and then staff can determine what that is, because I feel like we're pretty divided here, or at least kind of need more information to move forward.
Commissioner Baker.
Well, the problem is, from my point of view, it doesn't warrant more conversation. We're talking about a truly minor issue, and we're not going to ever come back and revisit it. So, if you're happy with the language, which isn't quite really what you're trying to say, or what we would think is implied, then that's fine. But we're never going to come back and visit this. There's no reason. I mean, we've spent more time on this than we already would have spent on any kind of minor. So we're not going to come back and revisit it. So the point is, if you're changing the code language, why don't you just fix it? And my position would, if you want to do it, you give them two wordings. You give them the or and give them the other language with this, which implies let them choose. And then, I think they're going to choose the other one, because that's what's going on.
Commissioner, that's what I was saying. So, because we're not the decision makers. So, yeah.
And we could say we personally, the city planning commission voted in favor of this one or that one. So many for this.
Commissioner Randall.
I think, in defense of my motion, leaving the word "or" in and the city manager in gets it much closer to just correcting the wording than any kind of policy change. And I think I'm hearing that maybe we shouldn't be trying to do policy changes on this, especially since only one person showed up from the public to this public hearing. I would be a little chagrined if I were a member of the public thinking they're just going to make corrections to stuff and then they end up making policy changes. And so I think we need to keep it as close to just a corrective measure as possible, and I personally think my wording does that.
Okay. I originally brought it up because I was told that in the absence of a plan, it's being made by the city manager, which makes sense, which means to me that if you do have a plan, then the city manager is out of it unless there isn't a plan. That is why I don't go with the or. But since we have a motion and a second on the floor, would anyone like to call that motion? We'll take a vote on it. We'll see what happens. Okay, so we have a motion that reads with the word or, seconded by Commissioner Borowski. All those in favor of that motion, raise their hands. Opposed? Motion fails. Is there anyone else who would like to make a motion?
Okay, I'll try a motion that uses the original wording that Commissioner Randall put through, that did not have the word or, but used the applicable plan unless it wasn't available. I don't have the exact wording. Could you read that, what you had
The original wording was Eugene's applicable parks. Eugene's? Okay. The original wording was the determination of park classification shall be based on Eugene's applicable parks plan or in the absence of a plan by the city manager.
I'll make a motion to use that wording.
Any second?
Second.
Seconded by Baker. Discussion.
I think it's a valid motion because it's the policy that's actually in action right now. We're not doing what's worded here. We're doing what we just described. So by changing this, we're actually going to what we're doing.
Any further discussion? Commissioner Randall?
I think I agree with that. I think that's a good point.
Any further discussion? All those in favor of the motion, raise their hand. Opposed? One abstention. One opposed, I'm sorry. Okay. Are there any other specific items we need to vote on? With the vote that we've taken, I would entertain a vote to move and recommend that we forward with that change what the staff has presented for code amendment changes to the city council.
So moved.
Any second? Second. Discussion. All those in favor? Raise their hands. Vote is unanimous. Well, that was simple. I'd like to thank the commissioners for their deliberations. We didn't have any public participation this evening, and I'll declare the Eugene Planning Commission meeting is now closed.